Good morning and welcome to this Legal Aid New South Wales law webinar on legal words for interpreters, criminal law. My name is Kerry Wright and I work in the Community Legal Education branch at Legal Aid New South Wales. I'm here today with Helen Shaw, who is a Senior Solicitor in the Legal Aid New South Wales Criminal Indictable section, and Sarah Hedberg, who's a solicitor also in the Criminal Indictable team. Hi Helen, hi Sarah.
Hello.
So to begin, we would like to acknowledge the traditional owners of this land. We would also like to pay respect to the elders of this land, both past and present, and extend that respect to other Aboriginal and Torres Strait Islander people attending or watching the recording, attending today or watching the recording. The purpose of this webinar is to explore common words used in criminal law settings. We have other webinars coming up focusing on family and civil law words, and we'll give those details at the end of the webinar. So Helen and Sarah, perhaps you can introduce yourself to our audience. So Helen, do you want to go first?
Hi everyone, I'm Helen Shaw and I'm a criminal law solicitor at Legal Aid, and we work with interpreters in many different languages on sometimes an almost daily basis. I just wanted to say that thank you for the work that you as interpreters and those that translate as well do, because we really need your help to communicate with our clients. As a criminal law solicitor, I appear in local court, district court and Supreme Court, and yeah, I love my job and helping people, and thank you again for your job.
Thank you. Sarah.
Good morning, everyone. My name's Sarah Hedberg. I'm a solicitor also in the criminal indictable section of Legal Aid in our head office in Sydney, when we're allowed in, which we're not at the moment. Like Helen said, interpreters do such a pivotal role in our criminal justice system. It can be overwhelming at the best of times, but particularly so when English isn't a person's first language. And I'm constantly impressed by your ability to interpret and help those particularly vulnerable clients. So thank you for joining us today, and hopefully you'll get something out of it.
Great, thank you both. All right, the slide coming up now is just an overview of what we'll be covering. Common words used in court, criminal process words, legal document words, words used in criminal law, words about offences, types of sentences, and where to get help with legal words. And just to let everyone know, there is a handout on your control panel which you can download, and there's a list of the words that we'll be covering today. It's a Word file and you can keep your own notes in that. But there will be an email after the webinar with details of where you can also find more information about words used in the criminal law setting. Okay, so as I said, today's focus is about assisting people in the criminal law settings who need interpreters. Criminal law is the largest part of legal aid work and the largest section of legal aid. The criminal lawyers at Legal Aid assist people charged with criminal offences appearing before the courts. We also have specialist services, including a children's legal service and a youth hotline, but we'll be talking about adult criminal law today. The drug court, a prisoner's legal service. So we're just interested, we're going to launch a quick poll with you all, just interested to find out about your experience to date with interpreting in criminal law settings. So I'll launch that poll so everyone can have a look at that, and just use your device to answer the question. How much experience do you have interpreting in criminal law cases? The options are quite a lot, a little bit, not yet, but I'm interested. None yet, but I'm interested. So I'll just give people an opportunity to have their vote on this, this poll question so that Helen and Sarah have an idea about your experience. So I'll close that now and share the results so far that we got. So Helen and Sarah, you'll see there The majority have done a little bit, 56%, 23% quite a lot, and 21% none yet, but I'm interested. So new interpreters in our system. Yeah, so that's good. So I'll hide
Wonderful.
that and we'll bring up our next slide. So this is our first slide, and Helen, I think you're going to start us off.
Yep, so every charge starts in the local court. So when somebody is charged with a crime, whatever that crime is, the first court you go to is the local court. Many charges, a large percentage of charges, will finish in the local court. More serious charges will go to district court, like armed robbery, sexual assault, things like that. Murder will go to Supreme Court, and so will terrorism. That will also go to Supreme Court. If somebody wants to appeal the length of their sentence or appeal against the conviction, then they can go from district or Supreme Court to the Court of Criminal Appeal, which is also a part of the Supreme Court, but it's an appeal court. And above all of those courts is the High Court of Australia, which takes cases from every state and territory. It's a federal court, but it's very hard to get to have your appeal heard in the High Court. They only allow a few appeals per year.
Okay, thank you. So Sarah, you're going to take us through the criminal process that's come up.
Thank you. So as Helen's already noted, criminal matters will usually start with an arrest. So the police will arrest someone and they'll charge them. What happens there is the police then make a decision about bail. What bail means is someone's right to be at liberty, so out in the community, whilst they're facing criminal charges. The police will either grant bail or they will refuse bail. If they refuse bail, the matter has to come before a court. Usually it'll be the same day or the day after. There's a requirement that it go to court as soon as possible. From there, the court will have to make a decision about bail, and we'll talk a bit more about the bail process later in the presentation. From there, depending on the nature of the matter, different processes occur, and again, we'll talk about those in more detail. But very simply put, at some point, the person is going to have to enter a plea. So that's saying whether they're guilty or not guilty of the charge. If they plead not guilty, the matter will go to trial or hearing if it's in the local court. If they plead guilty, the matter will go for sentence. So that's a very broad brush overview of the process, and we'll go into details of each of the stages in more detail as the presentation goes on. I should also just note, in terms of this criminal process, obviously there are criminal charges that are a lot less serious, like fine-only offences, where there's no need to make a decision as to bail. Someone just gets handed the notice that they've been fined and something like that. So it's not the case that for very low-level matters, this process would be followed. But for most criminal matters that you can think of, like stealing, sexual assault, robberies, the more serious matters, they all follow this broad process.
Okay, thanks, Sarah. So Helen, you want to take us through this arrest and police interviews?
Yes, so police will arrest somebody and a person might be offered a chance to speak to a lawyer, to phone a lawyer. Police will try to work out if somebody needs an interpreter, and as an interpreter you might get a call to go to a police station to interpret the person's rights while they're at the police station, or to sit in the interview with somebody and interpret the police questions and the person's answers. So I imagine many of you may have had a call to go to the police station. The lawyer may get called to go to the police station as well, and for some people they are required to have a support person present. It might be a friend or it might be a stranger that acts in the role of a support person, especially for somebody who is vulnerable, somebody with an intellectual impairment, for example, and also a young person, a child, or also certain categories of people like an Indigenous person. So there'll be different people at the police station. The police should tell the person that they have a right to silence, that they do not have to participate in an interview or answer any questions, and they're given a caution that anything that they do say can be used against them in evidence. And if a lawyer is requested to attend the interview with police, then there is a special caution which involves, a bit like what you hear in English TV shows, crime shows, about, you know, if you fail to say anything in your interview with your lawyer present, which you later wish to use as a defence in court, you may not be allowed to. So that's an extra caution if the lawyer is present. You may often hear the phrase in court, ERISP, E-R-I-S-P. That stands for Electronic Record of Interview with Suspect or a suspected person. And that is audio recorded and video recorded. It is the interview of police asking questions of a person that they've arrested. And those answers and questions are typed up and a transcript is produced, but the original evidence is, of course, the video. ROI stands for record of interview. It's the same sort of thing. Record of interview, or ERISP, is the same sort of thing. And when documents are produced by police and the charges entered, or information about a particular investigation, the police enter it into their database, which is called COPS, C-O-P-S, and an event number or a reference number is produced. And every charge will have what's called an H number. And you'll hear that when you go to the local court, you'll hear this all the time. The magistrate will refer to H number ending in 763, for example. So there'll be lots of paperwork, and some clients might have 3 different sets of arrests, 3 different sets of matters. Each one will have a different H number. And so the magistrate will let the lawyers know that they are looking at the paperwork for this particular event or this particular series of matters, and it'll have an H number. Each one will have that, and within that H number there might be 1 charge or there might be 10 charges. Charges are also called sequences. So you'll hear those sorts of words all the time in the local court. You might hear the prosecution saying, we're withdrawing sequence 2, 3, and 5. Okay, sequence is a charge. So they're just some terminology that you will definitely hear when you go to interpret in the local court.
Okay, so Sarah, you can talk to us now about bail or release applications. Thanks.
So bail, as I said in the previous slide, is someone's ability to be at liberty, so out in the community, pending the finalisation of their criminal charge. Bail can be decided, as I've already noted, at different stages. So the police can decide to grant bail, and it can also be the case that the court can decide bail. And that really depends to a large extent on the seriousness of the crime, as well as a person's past criminal history. What we mean by a show cause offence is there are certain offences and certain situations where the law says a person has to pass another hurdle before they get bail. So they have to show cause why their detention is not justified. Now, there's not a lot of guidance in the legislation about what that actually means, but it can be, just to give you some examples to make it a little bit clearer, it can be something like a person has really serious health conditions and treatment isn't available in custody. It could be that the person is particularly vulnerable in custody, maybe because they have an intellectual disability, or they might be Aboriginal or Torres Strait Islander. And in that case, there's that extra step to getting bail. Now, in terms of assessing whether someone should get bail, in every case, the police and the court has to look at the bail concerns. Now, there are 4 different types of bail concerns, and they relate to whether someone's going to turn up to court, whether someone's likely to commit further offences, whether someone might interfere with witnesses, and also whether someone might pose a threat more broadly to the community. So in every matter that the police or the court is deciding, they have to look at those bail concerns. And when you're translating in a bail application, generally what will happen is both the defence and the police prosecutors will address on those bail concerns. So you might hear people making submissions about various bail concerns. Now, what we mean when we refer to Section 74 is the law says that you only get one chance to apply for bail. So if I'm arrested today and I go before the court and the court refuses me bail, I'm not allowed to apply again to the local court unless I can pass the test in Section 74. What Section 74 says is that if I want to apply again to get bail from the local court, I have to demonstrate that that's been a relevant change of circumstance. To give you an example of that, it might be something like when I first applied for bail, I didn't have a residential address I could stay at. But since then, my aunt's come forward and she said she's happy to have me stay with her. That might be a reason that Section 74 is met, so there's a change of circumstance. At the moment, you might also hear people making submissions about COVID with Section 74, and that's because, as you're probably aware, there's been quite a significant number of cases in the prison system. So it can be lots of different things, but you have to pass that hurdle, another hurdle, in order to go for bail again. A Supreme Court bail is the option that exists once you've applied for bail in a local court or in another court and been refused. It's sort of the next step. So if I'm refused in the local court and I don't have any change of circumstance that I can rely on to apply again, I can go up to the Supreme Court and ask them to look at my bail or apply for bail again before the Supreme Court. Anyone who has translated in a release application is probably also heard reference to bail conditions. So when the police or the court make a decision about bail, they can impose conditions. Generally, bail is always subject to conditions, but the number of conditions will depend on the particular bail concerns that have been identified. So some typical ones that you might hear are a requirement to report to police. So the person might be required to attend, say, Newtown Police Station every Monday, Wednesday and Friday to report. And that's just to let them know that they're there and they're reporting, and that's sort of a check on them to make sure that they're willing to comply with court orders. You might also have a condition that you're not allowed to associate with specific people. So that basically means you're not allowed to have any contact with people that are listed in your bail conditions. So that might be someone who's been accused of the same crime as you, so a co-accused, or it might also be a potential victim. You can also impose, or the court can also impose a curfew. So for those of you in lockdown LGAs, you're probably familiar with curfews now. But basically the court can say that a person can't leave their house between certain hours. Often it's something like 8 p.m. to 6 a.m. And we often see that kind of condition where someone has a record of committing offences in the middle of the night, and it's to discourage them from doing that. The final condition that we've got there is a surety. This is probably where there's a lot of confusion about bail in New South Wales. So if you've ever watched an American crime drama, bail is often equated with putting up money. In Australia, and in particular in New South Wales, bail's a lot broader than that. So there's no requirement that you provide money as part of bail, but sometimes the court will ask either the person who's applying for bail or for someone else to put up some money. And that money is either put into court or a person agrees to forfeit it if the person on bail doesn't turn up to court. And it's often, I've found when I'm taking instructions for a bail application, it can be the source of confusion. The court's not going to, usually doesn't set an amount, it's up for the person to nominate an amount as part of their bail application. So that's something that it's important for, or it's helpful for translators to have an understanding of, because it's often something that kind of causes confusion in release applications, because everyone has the idea of an American style bail in their head.
Okay, thanks, Sarah. All right, so Helen, do you want to take us through this next slide coming up, the people at court?
Yep, so in court, of course, you'll see various lawyers, which there's various names for lawyers. There's barristers, there's solicitors. In the local court, you won't actually visually see the difference, because the barristers, who normally have a wig and the black robes in the district court or Supreme Court, they do not wear the wig and the robes in the local court. So it may be not possible to tell who is a barrister or who is a solicitor in the local court. And amongst barristers, there are senior counsel and junior counsel, or another name for senior counsel is Queen's Counsel. And when there was a King of England, it would have been King's Counsel. So senior counsel and Queen's Counsel are really the same thing. And both solicitor and barrister can speak in court, and solicitors also present matters, bail applications, sentences and everything. Usually in a trial, you'll see a solicitor and a barrister in court. In the local court, you'll see magistrates, and in the district court, you'll see a judge, and in the Supreme Court, we call the judges justice. They're a justice of the Supreme Court. When we talk to the magistrate, judge or justice, we say Your Honour. So that's what you refer to them as, Your Honour. And there'll also be registrars of each court, and they're really doing administrative tasks and maybe making some orders in respect to court dates and subpoena documents and things like that. You'll also see police prosecutors in the local court, and also DPP lawyers as well in the local court. And you'll see Crown prosecutors in the district court and Supreme Courts. You won't see the police prosecutor in the district court or Supreme Court. And the police prosecutors are not in police uniform, they're in a suit. So, and there's one more, which my little thing is blocked. A jury, yes. Jury, is in the District Court or Supreme Court, 12 citizens chosen at random to decide guilty or not guilty of an accused who's gone to trial. So juries are not in the local court.
So Helen, someone's asked a question about, and I'm thinking it's relevant to this slide because they might be in the court, the difference between a usual witness to a good character witness.
Oh yes, so when an accused person runs a trial, for somebody that has no criminal record, they've never been accused, they've never been convicted of anything, you might have some witnesses that you call in your case to say what a great person this man is, or what a great person this woman is. I've known him for 15 years, he's wonderful, I'm shocked that he's been charged with this, those sorts of things. That's a character witness. You can't do that if your client has a criminal record. You can't say, I'm such a great person, or I'm not a violent person, if in fact on your criminal record you have charges or convictions of violence, for example. So any other witness, that if you're not talking about what a great person this person is, other witnesses can talk about what they've seen, what they've heard. They're a witness to the events, so they're prosecution witnesses and other types of defence witnesses. Defence witnesses can also be alibi witnesses. They can also be expert witnesses, psychiatrists, toxicologists. So they're not talking about the good character of the person. There's a danger if you say you're a good character, but really you have a criminal record, then the prosecution will be able to show the jury your criminal record. Whereas normally, the jury do not normally know that a person has a criminal record because it's too prejudicial, and you want the person to have a fair trial on this charge, on this accusation. So hopefully I've explained the difference between witnesses and the specific character witness.
Thanks, Helen. Someone's asked, what's the difference between a judge and a justice?
Judge is district court and justice is the Supreme Court. it's just a different name, but they do the same thing.
And also, there's a question about the use of the term sergeant in the courtroom.
Sergeant, yep, sergeant is the police prosecutor. It's the rank. They're a police officer. Their rank is sergeant. And so the court will often say Sergeant Smith, Sergeant Miller, whoever, sergeant. They're the police prosecutor.
Okay, thank you. All right, so the next slide's coming up. Sarah, you're going to take us through the next two slides, I think. Common words used in court. Here's the first one.
Okay, so the prosecution is either the police or the the Office of the Director of Public Prosecutions. So in New South Wales, the function is divided. So if a matter is in the local court, it will be prosecuted by the police, and they have a special group of police who are police prosecutors. They're not necessarily lawyers, but their job is to prosecute matters. So they have a good understanding of court process, even if they are not legally trained as lawyers. In the higher courts, as Helen has already indicated, the matters are prosecuted by the Office of the Director of Public Prosecutions, or the Crown. Those terms are used interchangeably. And it's basically the state prosecuting matters in those higher courts. On the other side, you have the defence. The defence is someone who represents the person accused of a crime. So Helen and I are both defence lawyers because we represent people who have been charged with crimes. A defendant is someone who has been charged with a crime and is defending their matter. It's a little bit confusing because depending on what each individual court does or how they like to refer to things. Someone charged with a crime can be referred to by various different names. So generally when they're first charged, we call them the accused person because they're the person accused of a crime. If they decide to defend their matter, we might still continue to refer to them as an accused person, or we might use the word defendant. It just depends on the court practice. Once someone has either been found guilty of a crime or otherwise pleads guilty to a crime, we refer to them as the offender. Evidence in chief is the evidence that's led from a witness in a trial, and it's sort of the substance of their evidence might be the best way to refer to it. So as Helen already noted, a witness will come and give their evidence in chief, and that will cover what they saw, heard, or otherwise perceived about the event in question. That evidence is led by the party that is calling that witness. So in a criminal trial, the majority of evidence in chief will be led by the prosecution because they're the ones presenting the case. What then happens is the witness can be cross-examined by the other party, and this means that the other party, so the opposing party, gets a chance to test the evidence of that witness. So again, I know we keep referring to crime shows, but that's often what you see where the most exciting stuff happens in trials in criminal dramas. It's not always the case in real life that they're quite as exciting, but it is a chance for the other party to test the evidence of the witness. We've now got some, on the other side of the slide, we've got some terms for referring to why matters might be in court. As you've probably noticed, we use a whole lot of terms that sound complicated, but really just refer to very simple things. A mention is basically any thing before the court that doesn't really have anything substantial about it, but it's really just a procedural thing. So the way I like to explain it is it's usually just a chance for the court to check in with the parties about where a matter's up to check that we're moving things along as we should be. So some reasons something might be in for mention is for the court to check that the police have served the brief of evidence, so the documents that set out their case. It might be a mention to for someone to enter their plea, so plea of guilty or plea of not guilty. It's really just an administrative appearance before the court to let the court know where we're up to. We use the term fixed to say it's just a way of saying something's been put down in the calendar for that particular day. So you might hear fixed for mention or fixed for sentence. Again, it's just a complicated way of saying something quite simple. Hearing and trial. If a matter is in the local court and a person pleads not guilty, it's set down for a hearing. If a matter is in this district court or Supreme Court, we refer to it as a trial. As Helen's already noted, the big difference is that in the district court and the Supreme Court, a trial will usually be before a jury. There is the option to have a judge alone trial. You might have come across those, but that's generally the distinction between the different courts. A special fixture is generally something we see in the local court, and it's really just, most hearings in the local court are fairly short, usually they're a day or less, but sometimes the hearing matters in the local court can be quite complex, and it's going to take more than a day for the court to hear it. So they might get what's called a special fixture. So if I've got a hearing that's going to go for 3 or 4 days, then I'll be given an allocated spot in the court diary for that matter. The big thing with that is that you get a magistrate allocated to you ahead of time, whereas normally with a hearing in the local court, you turn up on the day of the hearing and just see who's available. So that's the key difference there.
Okay, thanks. We'll move on to the next one.
Okay, so committal hearing. We do still have committal hearings. They're not very common anymore because the law's changed. But basically what a committal hearing is for serious matters, so the kind of matters that Helen and I deal with in our jobs. They can't be finalised in the local court. They've got to go up to the district court or up to the Supreme Court. The process by which they move from the local court to the higher court is called a committal. Before the law changed, the magistrate was able to hear the evidence that the prosecution had in the matter and decide whether there was enough evidence to support the charges and therefore to commit it up to the higher court. You can still have something similar now, but the magistrate doesn't have the same powers, and it's not very common that you will have a committal hearing. A call over, again, it's a little bit like a mention. It's just a fancy way for saying the court gets an opportunity to check in with the parties and check where things are up to. Where we often use the term call over is when a matter is coming up for trial. And in the weeks before the trial is due to start, the matter will be listed for a call over for the court to check that all the relevant documents have been filed with the court and that there's not going to be any delays. An interim hearing or order, this interim basically just indicates that it's not a final order. This doesn't happen that frequently in criminal proceedings. Where you might hear it is maybe in relation to domestic violence orders, that there'll be an interim order made until the court has time to have a final hearing about whether a final order should be made. But it just means something that's sort of in place until the matter can be finalised. An adjournment is simply putting the matter to a later date. You might hear quite frequently in court someone seeking an adjournment, and they'll be required to provide reasons why they're seeking that adjournment. Stay or stay of proceedings. That's when you're asking the court to essentially stop the proceedings. So for the charges to be withdrawn and for no further proceedings to take place. This is fairly unusual. It doesn't happen that often, but it might be in a situation where there's some reason the matter can't proceed. If there's insufficient evidence or the accused person has certain disabilities or mental health issues, which means the matter can't proceed. There's, like I said, it's a fairly unusual thing, but you see it occasionally in the local court. And in the district court, you might get what's called a no bill, which is the district court equivalent of a stay. And that's related to, it's called a no bill because you have a bill of indictment, which I think we'll talk about later. But those are terms that you might hear in the district court. A forfeiture application is usually filed by the prosecution, and they would be seeking the forfeiture of certain property. So if someone's potentially made some money as a result of their criminal activity, the prosecution might seek for that money to be forfeited. Often it's the case that the police will have that money as part of their evidence, and it's just an order saying that the offender can't go back to the police and get that money back. A confiscation order is, I guess, the order that follows from a forfeiture application. So it might be that the money's confiscated, or potentially that the drugs that a person had on them are confiscated. It's a procedural thing to make sure that someone doesn't profit from their crime, essentially. Jurisdiction, we use this term in lots of different ways. We might refer to jurisdiction meaning which court has the power to hear proceedings. So, for instance, with serious matters, serious criminal matters, we would say either the district court or the Supreme Court has jurisdiction to hear that matter to finality, to finalise that matter. That's generally when we use that term, sorry.
Sarah, can you just adjust your microphone up a little bit? Someone
yes,
said.
Is that better?
Yeah, I think
Yep.
so. Just getting a bit of air through the microphone. Maybe it needs to come down a bit lower.
Sorry, it's a new microphone, so I'm not very well versed at using it yet.
Yeah, no, that's fine. Thank you.
So, jurisdictional error, again, refers to when the court doesn't have the power to hear a matter. And we say if they make an order and they don't have jurisdiction, we refer to it as a jurisdictional error. Judicial error is when the judicial officer has made, has made an error about the extent of their powers.
Someone was asking this question, how the case moves from local to higher court without the committal hearing. Is that something you can answer, Sarah, or would you rather Helen? No, you're right.
I can answer that. Yeah. It's just really done on the paperwork. So the defence, for example, is not asking for permission to cross-examine any witnesses. So the defence, for example, is not asking for a hearing of evidence of some witnesses, and they're pleading, for example, not guilty, and so just be paperwork sent from local court to district court or Supreme Court if it's a murder or terrorism charge. Likewise, if somebody is pleading guilty to the charge, they are committed for sentence to the higher court. For example, I'm pleading guilty to armed robbery, be committed for sentence to the district court. No need to cross-examine any witnesses, no need to make that application in the local court for a committal hearing. So it's just purely paperwork, and it will just go up to the higher court.
All right, well, we might move on. I'm thinking we'll do the next two slides and then we'll break. So Helen, you were going to talk to us about words used in criminal law.
So summary offence are offences, there's a Summary Offences Act, and a lot of those might just be with a fine. They stay in the local court and they'll just be dealt with a fine, most of those. Some things may be dealt with summarily, which they might have been able to be taken up to the district court, but the prosecution have decided to prosecute it and keep it in the local court. So it's dealt with summarily, which means it's dealt with in the local court. An indictable offence, indictable, indictment, and indicted, those three words are all related. An indictable offence is something in the criminal law carries 2 years maximum penalty or more. So it could be a 2-year offence, a breach of an AVO, or it could be murder. There's also strictly indictable, serious indictable offences of 5 years maximum penalty or more. An indictment is something that if you are interpreting in the district court or Supreme Court at the arraignment list, which is the next word on the list, you should be shown a piece of paper, which is the indictment, and it's the charges. The criminal charges are written on a piece of paper. It's called the indictment. And Sarah mentioned finding a bill. the bill of indictment. It's the charges which the prosecution has chosen to prosecute. They are placed on a piece of paper, and the judge's associate or the judge themselves reads out the charges and says, how do you plead, guilty or not guilty? And the person says guilty or not guilty. That's what happens at arraignment. The person is arraigned, they're asked how do they plead to the charges. And if somebody is acquitted, that is the equivalent of being found not guilty. So acquitted and not guilty, acquit and not guilty, the same sort of thing. Penalty can range from a fine to a community correction order to full-time jail. There are many penalties, so they range in seriousness from money to jail. Remand is when a person is charged and not given bail, they are on remand. They are waiting for their case to be finalised in court, whether it's sentence or trial. They're kept on remand in prison, and often they are not they're not able to do as much as somebody who's already sentenced and had their case finalised. Or you can be remanded in custody, held in custody, remanded. So it can be both a verb to remand somebody, or it can be a noun, remand. Custody is, you can be in police custody when you are arrested, so you are not free to go, you are under the control of the police. Or you can also be in custody in the sense of being in prison, under the control of corrective services in prison. Again, you're not free to leave. You might be on remand, or you might be serving your sentence. That's the word custody, what that means in criminal law. Verdict is the judge, whether the magistrate finds a person guilty or not guilty, or whether the jury in the district or Supreme Court finds a person guilty or not guilty. That's the verdict. Sentence is the penalty or the punishment. So again, it can be, you can have a sentence hearing where all the evidence and all the personal circumstances are listened to. Sentence about, or a sentence is also the punishment, the penalty. So the magistrate or the judge delivers the sentence, and that is what penalty the person will receive. Is it going to be jail? Is it going to be a certain order in the community? Or is it going to be a fine? The sentence can involve those sorts of penalties. A jail sentence has both a parole period and a non-parole period. So the prison sentence or a jail sentence has two parts, the parole period and the non-parole period. So you serve the non-parole period in jail, and then you are released on parole and you're under supervision in the community. So you're not quite free, you still have to obey certain conditions, but there is a portion of the sentence which is spent in jail and a portion of the prison sentence spent under supervision in the community. And we'll talk more about how a sentence is structured later. We'll also talk about types of sentences a bit later. You might hear the term minimum term and head sentence. The minimum term is exactly that, the minimum time that a person must spend in jail as part of their sentence. The minimum term is the non-parole period, whereas the head sentence is the maximum. It's the total time in jail. So a head sentence might be 4 years, but out of that 4 years, you may have to spend 3 years in prison as the non-parole period. A black direction is heard in jury trials sometimes. It's when the jury tells the judge or the justice of the Supreme Court that they are they're stuck. They can't all agree on the verdict for the charge, and so that we don't know. That could be 11 versus 1. It could be 6 versus 6 jurors, because there's 12 jurors. They can't come to an agreement about the verdict. So they'll write a note to the judge, and the judge will talk to the lawyers. And if that's the situation where they're divided, they're stuck, then the judge will urge them to listen to everybody, try harder, try to come to what's called a unanimous decision, all 12 of you agreeing on the verdict, and that's called a black direction. It comes from the name of a case called Black. And a hung jury is when, even with that direction, the jury still cannot come to a unanimous decision about guilty or not guilty. So they're split. They cannot reach a unanimous decision, and then after a certain period of time, they're still stuck, and the judge discharges them, lets them go home, and it's a hung jury. The charge probably has to start again with a new jury, possibly a new judge, new trial, start again, and see what the outcome is after another trial.
Okay, well, we'll go on to our next slide for some more words used in criminal law, and then I might ask a few if they're not already covered that people have asked.
So to charge somebody, there's a verb to charge. So police do that. Police will charge somebody with a crime, with an offence. And there is also the noun, a charge, and I referred to sequence before. So a sequence or a charge or an accusation, that's what the charge is. So the charge, you might be charged with armed robbery, or the charge is called armed robbery, and you'll be charged by police. So there's both a verb and a noun in English. Form 1 offences, this is an offence or a charge which the person admits that they did, but they're asking the court to take it into account when they are sentenced for a different, usually a related charge. And best way to is to give an example. I do a break and enter, and I steal a person's wallet, and in the wallet there is a credit card, and I go to the shop and I spend money. I buy things using that credit card, and it's not my credit card, so there's a crime in using somebody else's credit card. So I might ask the court, I admit that fraud using the credit card, but I'm asking you to take it into account when you sentence me for the break and enter. And I sign a document which is called a Form 1. So it's just a document, a specific form asking the court to take it into account. The advantage for the accused, or the advantage for the offender, is I'm not given a separate penalty for the fraud offence. I'm given a sentence for the more serious charge, and the judge knows about what else I did, but I'm not given a separate additional penalty for the charge which I'm admitting and asking to be placed on a Form 1. So there is some advantage to the offender. A backup charge is something that is related to another charge. For example, supply prohibited drugs might be related to have a related charge of a possess prohibited drugs. So I might have 15 grams of cannabis in my possession, and police charge me with supplying cannabis, and they charge me with possessing cannabis, and I tell my lawyer that I was not supplying, I was not selling that, I was going to use that for my own personal use. So my lawyer might then write to the police and say, look, can you withdraw the supply charge if she pleads guilty to the backup charge, which is the possess charge. She's guilty of possession of the drug, but she's not guilty of supplying the drug. So a backup charge is a less serious charge out of the same set of facts, the same circumstances. Sentence assessment reports, or SAR, are written by Corrective Services Community Correction Officer, which is the new word for parole officers. And those reports go straight to the court. So they're used for sentence, and they go through risk assessments, risk of reoffending. They assess for suitability for community service, for example, or home detention sometimes. And they are used by the court to assess whether that is an option to impose a penalty, including community service or home detention. The danger with these reports is they also quote the person's attitude to the offence. So the report writer might say this person has a very bad attitude, blames everybody else, does not take responsibility, and that is not what you want to see written on one of those reports. So they can be a real risk, and they don't always have much personal background information, and the report writer will also write, they might contact some people, some family members, or different medical, if there's a medical issue, then the person might contact the doctor to confirm that there's this medical issue for the person. So they are a risk, and if somebody's going to get full-time jail, then they're probably not a good idea to get the sentence assessment report, which is really looking at alternatives to full-time jail. So if you've got no chance of getting anything but full-time jail, then my thing would be I would not normally use one of these sentence assessment reports, because the risk is too bad. The risk is too great of getting a bad report. Agreed facts are used when somebody's pleading guilty. You work with the prosecution lawyer to have a summary of the evidence in the brief. So instead of the judge reading 10 lever arch folders of documents when you're pleading guilty, you have a summary of a few pages, and that is the agreed fact. So the accused person, who is now the offender when they're pleading guilty, that person writes, that person signs the agreed facts, and that is what the judge will read for the sentence. And sometimes there may be a dispute on one aspect of facts, so it may not be totally agreed, and the risk of having a dispute about the facts is you may have to call witnesses to cross-examine them on sentence, and if you lose the dispute about the fact that you're disputing, then you can risk losing some of your discount for pleading guilty. So there's a real risk of disputing things. The best thing is to try to come to a total agreement about what the facts are. The burden of proof is the onus. Who has to prove something? And in a criminal trial, the prosecution have to prove the ingredients or the elements of the offence beyond a reasonable doubt. And if in a civil matter, the test is balance of probabilities. So the burden of proof, or the onus of proof, is beyond a reasonable doubt in criminal trials, which is meant to be a very hard and high standard before somebody can be found guilty. The objective seriousness is something, you'll hear this all the time in sentence matters. The magistrate or the judge has to make an assessment comparing this break and enter, for example, to those other break and enters that they've heard in court. So what the factors of this one compared to the factors of those other ones? Is this more serious than those other ones or less serious? On the scale of seriousness, how serious is this one? So it can be very artificial, but they have to somehow come up with this is in the middle range of seriousness, or this is objectively much higher than anything I've ever sentenced somebody for, or perhaps very low range. So as defence lawyers, we're always looking for factors within the agreed facts to try to have the judge say that this is below the mid-range or low-level seriousness. We're always trying to get that sort of finding, because then the penalty may be lower. The higher the objective seriousness, usually the worse the penalty for that might be. Special circumstances, again, you'll hear this in sentence proceedings. Special circumstances are relevant in when somebody's getting a prison sentence, full-time prison sentence. You want to have a finding of special circumstances because the practical effect is that it affects the standard structure of the sentence. Normally a sentence is 75% or 3/4 non-parole period in jail and 25% or 1/4 on parole in the community. But if you have a finding of special circumstances, which may include very young person, very old person, mentally ill person, sick, maybe they have children that they need to care for who are going to be disadvantaged by the length of imprisonment, various factors, or they might have a drug habit which they really do need extra help when they get released in making sure that they don't relapse into taking drugs. So special circumstances will allow the judge to reduce the time in custody serving the sentence, reduce the non-parole period, and extend the period on parole. So instead of 75% in jail, 25% on parole, maybe you might get 60% in jail, 40% on parole, or if you're luckier, 50% in jail, 50% on parole. And that's with a finding of special circumstances. So as defence lawyers, we always try to convince the judge to make that finding. Precedent is, there are cases, so judges make judgments. Those become, often they are published and they become cases which we all read. As lawyers, we find cases which have similar facts or similar legal situations, and we apply the precedent. We try to follow the examples of past cases. So precedents are past judgments, past cases, and we apply those to, as new things come up, we're looking for similar examples. Common law and statute law. Statute law are politician-made laws. New laws are made every day, every week. They are statutes, acts of Parliament. Whereas common law is like tradition, and a lot of it goes back to England. We've adopted a lot of our structure and concepts from England, common law from England. Other countries have civil law from the Roman Empire. Like a lot of European tradition is actually from Rome, the Roman Empire. Common law, so they're not written down, they're just like traditions and laws that have developed over time. They're not made by politicians. So that's, hopefully that has explained those words. And were there any other words that
some people have asked some words which I think might be relevant when we go to the next slide, which is about legal documents. But I will ask this, Helen, what's the difference between remand centre, watch house, and a jail and prison?
Okay, good question. In New South Wales, we don't have watch house, but I think Queensland do.
Oh, okay.
When somebody's first arrested in New South Wales, you go on remand, you'll go into a jail and you get processed. So they'll check your health, check your mental health, and these days you get isolated as soon as you go into jail because of COVID. So people go into 2 weeks isolation as soon as they enter jail. And then people are classified and sent to different jails, but everybody is on remand. You are on remand until you are either have your trial and you're found not guilty, or until you're sentenced. You are on remand. There are different sections of jails or prisons. There are different sections. So some of them will have all their remand inmates, meaning unsentenced or untried inmates, in one section, whereas they'll have other jails will be for sentenced inmates who are serving their sentence. They've been to court and they've got their penalty and they're serving their sentence. Or there might be different sections within one jail: sentenced inmates, remand inmates. There are remand centres, as a big, like Silverwater, MRRC, Metropolitan Remand and Reception Centre is what MRRC stands for, and many of you may have had to go and do a conference at Silverwater. MRRC is one of the biggest remand centres, and I think there's one at Cessnock. There's different, Grafton, around the state there'll be different remand centres. When somebody first comes into jail, they'll go there, and then they'll be moved off to other jails once their health is checked and they're some sort of work out where they should stay until their case comes up in court. Prison and jail, there might be a technical difference, but we kind of use it interchangeably.
Yeah.
All right. Watch house is definitely Queensland. Sorry, watch house is definitely a Queensland word, but
okay.
I'm not. I think it might be. Your police put you there before you come to court, I think. I'm not sure how long you stay at the watch house for.
Okay, thanks.
Okay, so the first document we have on here is an affidavit. An affidavit is a legal document that has to be either affirmed or sworn by the person that is giving the information contained in it. It's a little bit like a statement where you're setting out information and you're basically then saying or swearing or affirming that the information in it is correct. The reason we have different terms: affirming is where it's not done on a religious text, whereas swearing is when it is done on a religious text. The person who sets out the information in an affidavit is called the deponent, because they're just deposing certain information, and they're the one who has to sign the affidavit. A statutory declaration really has the same effect as an affidavit, in that you're having to declare that the information in that document is correct, and you have to sign to that effect. And that's more used in everyday situations rather than in legal settings. So for instance, when you apply for an Australian passport, you have to sign a statutory declaration saying that the information you're providing is correct. Whereas affidavits are more generally used in a court context. I had to draft one this morning because we're seeking to have a sentence date vacated, and in that affidavit I had to set out why we're seeking for that sentence date to be vacated. So they're often used in sort of procedural matters. A notice of motion. So again, I had to draft one of these this morning because it's where you're asking the court to do something. So the example of what I was doing this morning is my notice of motion set out the orders I was seeking. So seeking to vacate a sentence date and have it relisted. It's basically just putting the court on notice of what particular orders you're seeking. And then you would have an affidavit in support which sets out why you're seeking those orders. This is often used more so in higher courts. You won't really see these in the local court, but they're sort of a more formal way of seeking orders from the court. A subpoena is a way to compel a person to either come to court to give evidence or to produce documents to the court. So if someone is required to give evidence in a hearing or in a trial, then they will be subpoenaed, usually by the police. And that subpoena is a document saying that they have to come to court. It'll be served on them, often personally, so they'll have to be handed the document. And if they don't comply with that subpoena, then there are potential consequences. For instance, they may face arrest. The court may issue a warrant for their arrest if they don't turn up to court. The other type of subpoena is when someone is required to provide documents to the court. Well, often, or the most common examples of when we might subpoena someone is we might subpoena police records that haven't been included in the brief or relate to other matters that we think are relevant to the case. So for instance, our client might tell us, you know, this witness has a criminal history, they've been convicted of lying to the court or something like that, and we might issue a subpoena to police to provide a copy of that criminal record. The documents are produced not to us, the party that's issued the subpoena, but to the court, and we then need to seek orders from the court to inspect those documents. I've already spoken about the oath and affirmation in relation to an affidavit, but it's also, you'll have heard it, when a witness is giving evidence, they have to either provide an oath or an affirmation, again, like with the affidavit, to say that their evidence that they're going to give is correct and true. The oath is sworn on a religious text, and an affirmation is a non-religious, not done on a religious text.
Thanks, Sarah. So someone had a couple of questions which I think is relevant to this section, asking about these words: submission, writ, and to wit.
Okay. So submission. So when a lawyer says things to the court, they make what are called submissions. So we might make submissions on sentence, and basically that would be me saying to the court, this is how we view the matter and what we think you should take into account. And those can either be done in court orally, or they might also be done in written form. And it's a way of making submissions is a way of persuading the court about what you say is the correct interpretation of this particular matter. A writ, we don't really see writs very much in criminal law. It's I'm not even quite sure how to explain it. It's an older form of document, how you used to commence proceedings back, I don't even know when. But you see it more probably in, you might see it more in civil proceedings. In criminal law, I guess the only example I can think of is a writ of habeas corpus. So basically, it was a way of, again, maybe a bit like a notice of motion, asking the court to take certain action. But it's very unusual in current practice to see writs issued in criminal matters. To wit, you've probably heard of barristers saying that, I'm imagining. It's just saying, oh, I don't even know how to explain it. I guess providing an example, it's just a turn of phrase. It doesn't have any particular legal meaning that I can think of, unless Helen has a better way of explaining it.
Sometimes you'll see it on a charge itself, like.
Oh yes, actually yes, that's true. Sorry.
like it's like specifying something. It's specifying the property that was stolen, for example. Somebody's charged with shoplifting, and there'll be a whole heap of examples of what they've
Yes.
stolen, to wit, the Xbox, the computer, the iPhone. It's just like such as, or for example, those specifying something.
Yeah.
Okay.
No, that's exactly where it's used.
Yes. Yeah. Well, this person said it's in written documents that they've seen them.
Yes.
But to wit. So there we go.
To
Thank
wit.
you very much. So now we're going to go on to offences against the person. You're going to take us through this one?
Yep. So common assault is the lowest maximum penalty type of offence against the person, 2-year maximum penalty, and will usually be dealt with in the local court. Common assault, it does not have to involve violence. It does not necessarily mean there has been physical contact or violence. A common assault could also be a verbal threat. It's really putting somebody in fear, or potentially making somebody think something bad is going to happen to them. So it can be a verbal comment or threat, can also be spitting on somebody, and can also be a physical contact, but not causing a scratch, not causing a bruise, things like that. So it's considered the lowest level of assault, but it can still carry a 2-year maximum penalty. Actual bodily harm, or assault occasioning actual bodily harm, ABH for short, is an offence which carries a 5-year maximum penalty, and it can the actual bodily harm can range from a bruise to a scratch, a red mark, or it can be much more serious. Can be almost as serious as grievous bodily harm. So there's a whole range of types of bodily harm within that charge. So you can imagine the penalties can really vary for 2 different people charged with that same charge. The penalties could be very different depending on what the injury is and what the circumstances are. Grievous bodily harm translates into really serious injury. So again, there can be a very large range of what is grievous bodily harm, and it might be injuries which cannot be repaired, or injuries that that are permanent, more permanent, and there might be an injury that involves having a metal plate put in the face. So I've had cases like that where the jaw was broken, or the eye socket was broken and metal plates were put in, and that was considered grievous bodily harm. Some things which you might be able to argue that if the injury can be repaired, that it's not grievous bodily harm. So there's a bit of legal argument sometimes about whether something is grievous bodily harm, and the prosecution have to prove beyond a reasonable doubt that it is grievous bodily harm. So there'll be medical records, there'll be medical evidence about what the injury is and what treatment was needed and what treatment may still be needed in the future. So these will require some medical evidence that the prosecution will usually provide: hospital records, a letter from the doctor at the hospital. A fray is quite a strange charge. It can be 2 people alone, or it can be 15 people in a park. It's behaviour that could have put people in fear. The people in the public, if they had seen it, it could have put people in the public in fear of some sort of violence happening. So even if nobody's around to see this, you can still be charged with an affray, and it can be 2 people, or it can be a big group of people. It doesn't have to involve weapons, but often affrays do involve weapons, and there's a 10-year maximum penalty for the charge of affray. brawl is not a criminal law word. We don't have a charge brawl, but really it's a fight, or often an affray will be called a brawl in the media, but the charge itself won't be called brawl. It will be more like a fray or some sort of one of these sorts of assaults, depending on the level of injury, if there is injury.
Okay. So earlier on, Helen, someone asked about these three terms. I don't know if that fits here. They are choke, suffocate, and strangle.
Okay, so strangle and choke, I guess, could be similar. You can, some charges, they're like strangle with intent to murder, think like an attempted murder, that there might be a type of an attempted murder by strangling or choking. You know, putting hands around somebody's neck, squeezing the neck, or putting material like a rope or cloth around somebody's neck, choking them or strangling them. And whether or not that's done with intent to kill them, intent to murder, depending on what the intention is, there might be a higher charge, like attempted murder by that method. Suffocating is, I guess, you know, example, putting a pillow over somebody's face and stopping them from breathing. It might be that, again, if it's done with an intention to kill the person, then the actual charge might be an attempted murder, or if the person does actually die on any one of those charges, any one of those actions of choking, strangling, or suffocating, if the person dies, then the accused might actually be charged with murder. So,
Okay.
yeah.
All right. Well, thank you. So, Sarah, you're going to take us through the next slide coming up, sexual offences. Thanks.
So in New South Wales, we don't have a crime of rape, we have a crime of sexual assault. And it's broader than our probably everyday understanding of what rape is. It extends to any penetration of a genital area. So it includes the insertion of fingers into someone's vagina. And know some of these terms can be a bit difficult, but I think it's important that we use them so there's an understanding and you can translate them properly. So it's broader than what we might commonly understand rape to be. And it can include inserting any part of the body into someone else's genitalia, and can also not even a body part but an object as well. Sexual touching is sort of a step down from that, in that it doesn't involve any penetration, but is touching that has some kind of sexual overtone, I guess is perhaps the best way of putting it. So it might be touching someone's body in a sexual way or something of that nature. It was previously called indecent assault, but the law was changed about 2 years ago, and this new offence of sexual touching was put in place. The next step down from that is a sexual act, so it doesn't necessarily involve the touching of the person, but is in some way a sexual act directed at the victim. So an example of that might be someone masturbating in front of someone, might be an example of a sexual act. Sexual harassment isn't a crime per se. Depending on what the sexual harassment is, it might amount to one of those other three categories. So sexual touching a sexual act or sexual assault, but there's not a specific crime of sexual harassment. Sexual harassment can also obviously be dealt with depending on what it is in a civil setting as well. The Child Protection Register is for people who have been convicted of a child sexual assault charge of some kind, and they are placed on the register and they're subject to certain restrictions depending on the nature of their conviction and how serious it is. So for instance, they might be restricted from having access to mobile phones or the internet, or it might be sort of less onerous than that. And they're placed on that register for a period of years depending on the seriousness of their crime. In relation to consent, consent is an element of sexual offences. So in order to prove, for instance, sexual assault, the prosecution would have to prove both that the complainant, so the person who has said something was done to them, did not consent, and the Crown or the prosecution would also have to prove that the accused person knew that the person wasn't consenting. Consent under the criminal law is quite complex, and it's often where trials or often trials are run on the issue of consent, whether the person consented and then whether the accused person had knowledge of that consent. And the legislation sets out in quite a lot of detail what is consent. This idea that it has to be freely and voluntarily given, and there's certain laws around when a person can assume that someone has given consent and when they can't. Aggravated we use that term in a variety of ways, but in the context of sexual offences, and particularly sexual assault, there's a crime of aggravated sexual assault, and it carries a higher maximum penalty than the simple form of sexual assault. In order to prove that, the Crown would have to prove that certain circumstances existed when the sexual assault took place. Some examples, or perhaps an example that's more common, is if the sexual assault took place in company. So if two or more people were involved in perpetrating the sexual assault, that might be a circumstance of aggravation, or that would be a circumstance of aggravated sexual assault. And the legislation sets out what amounts to aggravated sexual assault. In New South Wales, the age of consent is 16. Before that age, the law assumes that a person is unable to consent to sexual intercourse. And after that age, it's obviously a matter for evidence to establish that the person did consent. In terms of someone below the age of 16, trials will often revolve around whether the accused person knew the person was under that age when they engaged in sexual activity, because obviously if a person had a reasonable or was reasonably mistaken as to the age of that person, that can operate as a defence to the charge. Historical sexual abuse, it's not a specific offence, but it describes sexual abuse that has happened in the past, and often there's no definition of what amounts to historical sexual abuse, but often it's matters from the 60s or 70s where a person, for whatever reason, has delayed reporting it to police, and has only recently come forward and reported that matter. It can be a little bit complicated because a person has to be charged with the offence as it existed at the time it was committed. So the police have to look back at the old laws and work out what's the appropriate charge as it then existed to charge the person with. And in the wake of the Royal Commission into Historic Sexual Abuse, there's been quite a lot of these cases. So it might be that people have had experience in interpreting in these kind of cases. But there's no specific crime of historical sexual abuse, but it just relates to older charges that for whatever reason weren't prosecuted at the time.
Thanks, Sarah. Someone's asked a question about this term pre-recorded hearing in a child sexual assault case and also a ground rules hearing.
So the criminal law has adapted special procedures for child sexual assault matters, and that's to recognise that children giving evidence in court is particularly difficult, and so the law's been adapted to try and make it a less traumatising experience for them. So the way it works is, in these matters, a child will give an interview to police, and that's usually done when the matter is first investigated or when the complaint is made. That evidence forms the evidence in chief for that child. So it's done as a video, and that video is played to the court. And that is intended to prevent the child from having to come and give that evidence again in front of the court. What happens then is the cross-examination isn't done in front of a jury or isn't done in the trial, it's done as a pre-record. So it's pre-recorded. So the way it works is the lawyers for the defence and for the Crown will go to court, the judge will be there, and the child will come up on a screen. They'll be in a remote room somewhere in the court building, but we don't know where. And the defence barrister will cross-examine the child. Where the ground rules hearing comes in is that that child will be interviewed before they're cross-examined by a witness intermediary. That's someone, often a speech pathologist or someone who's an expert in children and the way they speak and the way their memory works. And that intermediary will write a report and recommend certain ways of asking questions of the child. So it might be things like the way you phrase questions. So not asking questions like, that's wrong, isn't it? Because those kind of questions can be confusing to a child. Or presenting different ways of giving evidence, like giving them an actual timeline to put things when things happened and things like that. The court will hold a ground rules hearing to establish what rules will apply to the lawyers asking questions, and that'll happen before the pre-record. The interview with the child with the police, plus the recording of the cross-examination, then becomes that child's evidence in the trial. So when the actual trial starts, the child doesn't have to come to court. The recordings will just be played for the jury. People have different views about whether this is a good idea or not, but it does mean, I know Helen had a matter where the trial had to start again, and it meant that the evidence could just be played and there wasn't a need to ask the child to come back and give evidence multiple times. So hopefully that answers that question.
Yeah, that's really comprehensive. Thanks very much, Sarah. Okay, so we'll move on to offences property, which I think, Helen, you're taking us through.
Yep, so theft or steal from person is, steal from person has the same maximum penalty as a robbery, but the difference is there's not violence, like not a threat of violence or actual violence. It's more like a bag snatch or something like that. Still unpleasant, but the difference is the threat or lack of threat or actual violence. Theft can also be done from a home, steal from person from the actual wallet or a handbag or something like that. Larceny carries a maximum penalty of 5 years. Shoplifting as well, stealing, they're all same sorts of maximum penalties. Obviously, shoplifting is from a shop or a store. Larceny may not be necessarily from a shop or a store, but they're all stealing some property that is not yours with the intention of depriving the owner of that property. So you don't have the intention of giving it back, or you have the intention of taking it for yourself, taking it or to sell it. So they're all similar words. There's so many types. When you look in the Crimes Act, New South Wales 1900, there are so many different types of larceny or stealing. There's lots and lots of sections, but essentially the maximum penalty is 5 years. Robbery, there are different degrees or different levels of robberies. So a robbery with one person can be the same maximum penalty as steal from person. There's a threat of violence or actual violence. So it might be a verbal threat or it might be a physical action of violence and the taking of property. So that's where that element of threat or threat of violence or actual violence is part of a robbery. Robbery in company is more than one person doing the robbery. Then, of course, with robberies, more serious than that is an armed robbery, a robbery with a weapon. So, and the maximum penalties go up according to robbery in company and armed robbery both have the same maximum penalties. And they will be dealt with in the district court. The robbery in company and armed robbery will be dealt with in the district court. Burglary or break and enter. In New South Wales, we don't have a charge called burglary, but I think in the past it used to be more like night, to do with whether it's day or night, as I understand it. But break and enter, a break is opening a door or a window or entering, having to broken the seal, or you're pushing a door open. It may not be locked, but you're still not permitted to enter, even if the door is closed but not locked, even if the door is unlocked. So break and enter is some people break through the window. It doesn't mean you're smashing the window. It may be opening the window to go in. Break and enter. You often hear break, enter, and steal. The charge is actually break, enter, and commit a serious indictable offence, and that could be anything that has a 5-year or more maximum penalty. So might break in and commit larceny, which is 5-year maximum. Might be break in and cause an assault, occasioning actual bodily harm on somebody, but whatever it is a serious indictable offence. And frauds, a big range of frauds. Some are Commonwealth legislation prosecuted by Centrelink. Might be fraud against Centrelink, claiming money that you're not entitled to, claiming certain benefits that not entitled to. So it might be a Commonwealth prosecution of fraud, or it might be a fraud. I used the example before of using somebody's credit card that I've stolen and going to the shop and making purchases, pretending that the credit card is mine. So obtain money or obtain benefit by deception is a type of fraud. Obtain benefit by deception is I'm pretending to be somebody else and I'm getting the money or the goods property by pretending to be somebody else and using their money, using their credit card. So that those are charges which you can be accused of. Hacking, we don't actually have a charge called hacking, but it's very common. Computer frauds, internet-based frauds, hacking into stealing people's identity, stealing people's bank account details, and to make transactions which were fraudulent or not authorized. And identity theft, yes, people having either new identity, often mail is stolen from letterboxes, and people obtain names and then they might open up a bank account with somebody else's identity, get new ID as somebody else, and it becomes quite hard for the victim, loses a lot of money and has a lot of stress of things being done in their name without their authorization. So those are some of the property offences.
The one at the bottom there, Helen, is obtain benefit by deception.
Yeah, so I think I just mentioned that with using, for example, I might use a credit card, and the benefit is I buy things. The benefit to me is I buy things with somebody else's credit card, for example, or it's a type of fraud. It's an action which I'm using somebody else's identification, or I'm pretending to be somebody else, and I'm getting some sort of a benefit, example, money or property, because I've lied about who I am. I've deceived the other person. And yeah, so that's the deception.
All right, well, we'll move on to the next slide, which is about alcohol and drugs. So Sarah, you're going to talk about that, and someone asked a question you might address this when you're talking about commercial quantity versus large commercial quantity.
I can talk about that.
Thank
you. And illicit drugs, they're covered under a particular act called the Drug Misuse and Trafficking Act, and that act contains a schedule which has a list of prohibited drugs, is the phrase we use in the legislation. And there are various other forms of legislation that cover other types of drugs. So for instance, drugs which you can get with a prescription, but if you don't have a prescription, it's an offence to obtain them. We divide the crimes in relation to drugs into a couple of categories. The main ones that you'll probably come across are possession, so having a drug in your possession, and the other one is supply, so supplying drugs to someone else. We don't in New South Wales criminalise use. The mechanism, I guess, for criminalising that is possession. The only way we criminalise use, and I'll talk about that over when we talk about the other ones, is driving under the influence of drugs or driving with alcohol or drugs in your system. In terms of supply, the definition of supply under the law is a lot broader than we would consider it in everyday language. So it extends to agreeing to supply, and it also extends to situations where you have a certain amount in your possession. So Helen gave an example earlier about a backup charge, and used the example of a supply and a possession charge. So what the law says is that if you have over a certain quantity of drugs in your possession, then the law deems you had those drugs in your possession for supply. So the amounts differ depending on the drug, but once it reaches it's called the trafficable quantity of a drug, then the police have the option to charge a person with what's called deemed supply. The person who's charged with that can then try and have that charge removed by saying, no, I didn't have it for supply, I had it for another reason. Usually that's a person having it for their own personal use, and that's a defence to the deemed supply provisions. In terms of the commercial quantity and large commercial quantity question, the Drugs Act divides each drug into 4 different quantities. So there's the small quantity, the indictable quantity, the commercial quantity, and then the large commercial quantity. The purpose of doing that is that once you reach a certain threshold, it either affects the penalty or it affects where the matter can be finalised. And it's also a way of categorising how serious an offence is. So there's a schedule, as I said, at the back of the Drugs Act, and that sets out all the prohibited drugs, and then it contains those 4 quantities as well as the trafficable quantity. And obviously once you're getting up to large commercial quantities and even commercial quantities, the penalties get a lot more serious, and there are separate offences which apply to those amounts. The MERIT program stands for Magistrates Early Referral into Treatment. It's a local court program, and the idea is that it gives someone who is accused of a crime the opportunity to seek treatment. And the idea is that if they complete that treatment successfully, they can use that to their benefit on sentence, in that they can say to the court, they've essentially made steps to rehabilitate themselves and to seek treatment for the underlying drug or alcohol problem that led to their offending. And the MERIT program will provide a report to the court which sets out how that person has performed. So in terms of alcohol and drugs and driving, obviously the law prohibits someone from driving under the influence of alcohol and drugs in certain situations. With alcohol, it's divided into low, middle, and high range. So that's looking at your blood alcohol content and how much alcohol you have in your system. Obviously, it's not illegal to drive with very low levels of alcohol in your system, but once you reach a certain level, it becomes illegal, and there are penalties that can be imposed. So for the lower end amounts, it's usually a fine and a disqualification period from driving, and the higher it goes, the high range ones, there is the chance of imprisonment, particularly if you're a repeat offender. And sometimes it's called a PCA offence, which stands for prescribed concentration of alcohol, and again, that's looking at your blood alcohol concentration and how much alcohol you have in your system. In terms of drugs, it's slightly different. We don't look at the amount in your system. It's just the fact that it's in your system, and that gives rise to an offence. There's a separate offence for if the drug is affecting your driving, but it doesn't have to be affecting your driving for it to be a criminal offence. The mere fact that it's in your system is enough. So that's some of the terms you might see, particularly in the local court. The local court deals with a lot of driving under the influence charges, so you might hear some of those terms, particularly in the local court.
Okay, thanks, Sarah. And Helen's brought to our attention where people can find out more about those drugs and the different definitions of quantities. So it's got, Helen's written here, it's the schedule to the Drug Misuse and Trafficking Act of New South Wales. So that's where you can find more information about different drugs and the quantities and the penalties attached to that. I've got a question here. Since supplying drugs is an offence and for personal use is allowed, how can a person obtain drugs for personal use when supply isn't allowed?
Yes, I mean, it's still, that's an age-old question, but the act of supplying is illegal. The possession is illegal. It's only the use that isn't illegal. But I guess because it's too hard to enforce someone using drugs. So in effect, we criminalize everything up until the point of use as a way to try and criminalize drug use. And that's just the model we've adopted. But yes, I take the point that use of drugs has to have involved some kind of criminal activity, but we don't criminalize that.
The actual use. Okay, thank you. All right, we've got a slide coming up here, domestic and family violence, and I think, Helen, you're going to take us through these words.
Yes, so DV stands for domestic violence, FV, family violence, and DFV, domestic and family violence. So if you're in the local court interpreting, you may be asked to interpret in an application for an AVO, which is an apprehended violence order. An ADVO is apprehended domestic violence order. So between people within a relationship, and that can be husband and wife, can be mother and son, mother and daughter, father and daughter, father and son, can be children, can be abroad, whoever lives in the home is in a domestic relationship. Apprehended personal violence order, a very common example is neighbours, so the people are not living in the same household, or they're not in a domestic relationship of some sort, but they are somehow known to each other, or they may not be known to each other. In fact, it could also be workmates, but very common is the neighbourhood dispute. And one neighbour will apply to have an apprehended personal violence order against the other neighbour. And so you might have to interpret in these cases in the local court, and they are civil proceedings, but the consequence of breaching or violating an order can be a criminal charge. So there can be jail penalties if you are found guilty of breaking one of the orders that's been made against you. So they are heavily related. AVOs are heavily related to both criminal law and family law as well. But the actual proceeding and the test is the balance of probabilities. It's a civil test, not a criminal test. And each courthouse will have a whole day full of these sorts of matters listed on the court day. And if it's an ADVO, police can take out a domestic violence order on behalf of somebody. So police may charge somebody with assault or damaging property and also take out an apprehended domestic violence order on behalf of the person in need of protection, which is referred to as the PINOP. And the police will then represent the PINOP, or the person in need of protection, in court. They do not need to hire their own lawyer. They will be represented by the police sergeant. Now, people accused of domestic violence or personal violence, people can consent or agree to these orders without admitting guilt. They can make consent without admission, which means that the orders will be made against them for a number, usually 2 years, sometimes more. And they're not found guilty, they're not convicted, they're not penalised, they're not fined, but orders are placed, and if they breach or break any of those orders, then the police can charge them with breaching those orders, and then they can face jail penalties for the breach if that's proven. If somebody does not want to agree to the orders, and they don't have to, but if somebody does not agree to the orders being made without admission, then they can take it to a defended hearing. They can go to court and either defend themselves or get their own lawyer and defend the allegation of the act that's given rise to the application for the orders. If unsuccessful, then the orders will be made, but if successful, then the orders won't be made. So if the person wants to challenge and defend it, then the victim, the pin-op, the alleged victim, or the person in need of protection will have to give evidence and be cross-examined. And then the court will decide whether to make any orders or not. When police first lay the order, or when an application is first made by somebody for one of these orders, and people can go themselves to apply, they can apply at the court for these orders, there will be provisional orders in place, and then there'll be interim orders in place until the court makes a final decision, until the final hearing or final orders are put in place. So while the provisional and interim orders are in place, you are still under condition you cannot breach these rules. You cannot break these rules. So if you breach any conditions before the final order or final decision is made about whether to make any orders, you can still be charged with breaking the orders. So it's very important that for the person to understand what they can and cannot do. Otherwise, they may end up getting into more criminal trouble. Conditions can include do not go anywhere near 500 metres from a particular property where the person lives or works. It might be don't consume alcohol within 12 hours of talking to that person. There'll be standard conditions such as do not assault, molest, harass the person, and that includes, text messages, which are, 100 text messages in a day, making threats. It can also include verbal, telephone calls, text messages, internet comments, social media. That can all be harassment. That can all be intimidation, threats, and things like that. Can also, they're illegal, and it's also a condition that you cannot do that. An assault, as we said before, common assault can be verbal as well as physical, so not allowed to assault the person. And then there might be some very specific conditions depending on the circumstances of the original allegation. And as I've said, it is a crime to break the rules, to breach the orders. That is a criminal offence, and it can carry a maximum penalty of 2 years in jail. So it's serious to be accused of breaching.
Oh, sorry, I was just reading this question. Someone's asked, Helen, what's the difference between interim and provisional orders?
The provisional order, I believe, is the first when police take out an AVO, when they apply for it. So even before it's gotten to court, and then when the court, when the paperwork's before the court and there's that first court appearance, then, for example, if somebody is defending, they're asking to defend it, then the magistrate might make interim orders until the date of the final or the next court date, or until the date of the hearing. Interim orders will be in place, temporary orders in place. Mm-hmm. So, and the orders might change from one court date to another if it's decided something else is necessary or something is not really necessary.
And I think you might have explained this, but just someone's asked this difference between DV, FV and DFV.
Well, they're very similar, and they might be quite interchangeable because domestic is people within, it's quite broad. So people in a domestic setting may not be blood relations either, though. So you may have a friend living with you that is in a domestic relationship. They're living within the household, whereas family may be more the relationship, the genetic relationship, but they are very interchangeable terms. But domestic is really it's and people within that household, so they don't have to be relatives of each other, but they might be housemates in a domestic. They're living in the same home, and so there might be a DVO against one of the housemates, for example, or a person might be threatening one person, like one person in the house, and a stranger might be threatening somebody within the house, and the AVO might protect everybody within the household in the domestic setting. So you can't assault, molest, or harass anybody that the alleged victim is in a domestic relationship within that household.
Okay, thank you. So Helen, you're going to take us through this slide, which is about sentencing discounts.
Yes, so when you're interpreting in the local court, you will, or in conferences with clients and their lawyers, you will hear discussion about discounts. And if you are interpreting in sentences, you will also hear the judge refer to what time the person pled guilty and what the appropriate discount is. So the legislation states that for people that plead guilty in the local court, they're eligible for a discount off their sentence of 25%. So a 25% discount off their sentence, meaning off the time that they would normally have gotten. In practice, for example, if the judge thought that the sentence was worth 4 years in jail, then the discount of 25% for pleading guilty in the local court would mean that the sentence would now be 3 years imprisonment instead of 4. So that's in practical terms how it works. But that's only for people that plead guilty in the local court before they go up to district court or Supreme Court. People that plead guilty in the local court and have their matters stay in the local court, obviously the idea is the earlier that you plead guilty, the earliest opportunity when you could plead guilty, when the charges have been negotiated and you've pled guilty straight away, then you should be eligible for a 25% discount. The idea is that you've saved time and money, and that you have saved bringing witnesses to court, and you've let everybody know that you're going to plead guilty at an early stage in the proceedings. The part of the reason why this was brought into the legislation was because there had been a huge number of cases in the district court, in particular, backlog, long delays, and they wanted people to plead guilty early instead of pleading guilty on the first day of the trial, instead of getting a trial date and then choosing to plead guilty. So they're trying to encourage people with an incentive. If you plead guilty in the local court, you will be eligible for 25% discount. If you plead not guilty in the local court and go up for trial in the district or Supreme Court, whatever your case may be, then the most you're eligible to get as a discount off sentence, if you later decide to plead guilty before your trial starts, the most you could get is 10% if you plead guilty more than 2 weeks before the trial date. But if you plead guilty less than 2 weeks before your trial date, or worse on the day of the trial, then you're only eligible for a maximum of 5% discount off your sentence. So the timing of the plea of guilty is very important. If somebody is going to plead guilty, then they're encouraged to really think about doing that in the local court to maximise the discount off the sentence.
Okay, and Helen, do you want to keep us talking about sentences with this slide, looking at the
Yes,
different
that's
types
fine.
of sentences?
So the worst sentence that somebody can get is full-time imprisonment. And that is a sentence, as I said before, there's two parts. Part of it is served in prison and part of it is served in the community on parole under supervision. So that's the worst sentence that you can get. And in New South Wales, if somebody gets life imprisonment, then life means you die in jail. You're there for the rest of your life. It never used to mean that, and different states have different situations, there might be different definitions, but full-time prison is the worst sentence that you can get. An intensive correction order is a jail sentence served in the community. So it's still a prison sentence, it's still serious. Short version, ICO. So it's a sentence of imprisonment. For one charge, it's 2 years or less, whatever, but it can't be more than 2 years if there's one charge. If there's more than one charge, the magistrate or judge might make what's called an aggregate or a total ICO. There might be 2 or 3 or 4 or 9 charges, aggregate ICO of 3 years or less. But you're not eligible for it if the sentence is going to be more than that. And the idea is that, yes, it's a prison sentence, but the idea is that the community is better protected by having this person do their sentence in the community with conditions. There might be community service order, there might be home detention if the person is deemed suitable for those options. And that's where you need one of those sentence assessment reports, the SARS that I mentioned earlier. Another condition might be don't take drugs or alcohol. And another condition might be go and get treatment, psychological, psychiatric treatment, those sorts of conditions. And the conditions will be depending what the problems are for that person. So the judge will have listened and read material produced on sentence and work out what problems there are and what issues need help, and work out the conditions for that person. And you must be supervised by community correction. So you have to turn up to appointments, do courses that they direct you to. And if you break the rules of your intensive correction order, you do not come back to court. You face the prospect of going back to jail, and you go before the parole board, the state parole authority. Community correction order, CCO, is not a prison sentence, but it does carry a conviction. So you are found guilty, you've pled guilty, you're found guilty, you are convicted, and it is a period where you must be of good behaviour, and you may have to be supervised, and there may be some other conditions like getting treatment. There might be some other conditions, and it'll be a fixed period of time that you are under this order, but it's not jail. And if you break the orders, then you have to go back to court and maybe face being resentenced or having that community correction order cancelled, revoked, cancelled, and facing a tougher penalty perhaps. Conditional release order, or a CRO, is also not a jail sentence. It's like a bond, like the traditional good behaviour bonds. They're no longer called that, they no longer exist, but these are like the replacements. And it's meant for lower levels of offending. And you can't get home detention on that. Home detention's only for an intensive correction order, possibly. So it's less serious charges, but you can still be, it's still on your record, it's still conviction. Court fines, you can also get a fine by a magistrate. So there'll be, the Crimes Act will have penalty, what's called penalty units. It will have maximum amount of penalty units, might be 10, might be 5. One penalty unit is $110. So the magistrate can also impose a fine, or a judge can impose a fine. You don't get many fines in the district court, so this is more of a local court thing, but yeah, you can get fined, and you can apply to have extra time to pay off the fine if you can't afford to pay the fine within 28 days. Section 10, subsection 1A is another type of penalty where the charge is dismissed and there's no criminal conviction, and that's usually for somebody that's come to court first ever offence, no prior convictions, and they would, depend, if it's not so serious, then they would be certainly eligible to try to apply for one of these section 10(1)(a), dismissed without conviction. And often young people at drug charges, at music festivals and things like that, if it's their first time before court, they might get one of these. And likewise, somebody that's older and never been in trouble with the law, no criminal history, and comes before the court with not the most serious crime, then they might also, because of their good criminal history, good character, might be eligible for one of those penalties. A section 10(A), you're convicted, but there's no other penalties. There's no fine, there's no good behaviour bond for a period of time. It's just convicted and no other penalty. And the usual time that you see this will be somebody might be serving a prison sentence for something else. They're not working, they've got no access to paying a fine. There's really no point inflicting a good behaviour, a community correction order, because they're in prison. So the magistrate may just give them a 10(A) conviction with no other penalty, for an example.
Thanks, Helen. Well, someone said, what is found guilty but no conviction?
So you admit, either you admit your guilt and you've done it, you've done the crime, or it might also be that you may have pled not guilty but been found guilty, but the penalty is no conviction. The penalty, it might be the section 10(1)(a), no criminal conviction imposed, or the charge might be you've done it, but it's going to be dismissed and no criminal conviction. So it's level of leniency, even though you might have done what you're accused of.
Okay, thank you. So Sarah, do you want to take us through this slide, which is coming up about how a full-time sentence is structured?
So Helen's already touched on some of these concepts already, but we'll go through it again. Basically, as Helen's explained, the majority of sentences in New South Wales are divided into two parts. The first is the non-parole period, and that's the period that has to be served in prison. And then you have a period of parole, which is served in the community, but under the supervision of community corrections. There is also the option to have what's called a fixed term sentence, and that's a sentence where all of the time is spent in custody and there's no non-parole and parole period set. That would usually occur with short matters. So a sentence has to be over 6 months in order to set a non-parole and parole period. So if you had a 3-month sentence, it would be a 3 months fixed term sentence with no parole period. There is also the option to have a fixed term beyond 6 months, but it's pretty unusual that you would. Once you get beyond that 6 months, you generally have a parole and non-parole period. As Helen has already explained, the law says that the usual practice is that a person spends 75% of their time in custody and 25% of their time on parole. So we always use the example of 4 years because we're bad at maths and it makes it easy. Well, at least I'm not great at maths, so it makes it easy. That if you got 4 years, you'd spend 75% or 3 years in custody and then a year out on parole. But as Helen's explained, that ratio can be altered by the court if special circumstances are found. There's no set categories of what amounts to special circumstances. It can be a whole range of things. But what it's looking at is that there's some reason why someone needs to spend longer time in the community. And that might be that they'd benefit from having supervision, they'd benefit from having, particularly with things like drugs or mental health, they'd benefit from having someone supervise their time and their integration into the community. There's a whole range of reasons why someone might have a finding of special circumstances made, to the point where someone has made the comment that they're not that special because a lot of people get them. But the idea is to acknowledge that, and with good reason, that people benefit from being in the community and reintegrating within the community. And that's the idea more broadly of parole, that obviously prison is a particular environment where it's very regimented, where there's a lot of structure and not a lot of choice by the people in custody. And so parole is meant to be an opportunity of proving that they can be in the community and not commit offences, but providing them support in the community.
Okay, thanks very much, Sarah. So Helen, we've got this slide coming up about mental health. If you can take us through words on this slide, that'd be great.
Sure. So we have a lot of people that, we have a lot of clients that have mental health issues, various mental health issues, various mental illnesses. And some of our clients do not understand what they're charged with. They do not understand things when we try to explain it to them. And there's this question of whether they are fit to stand trial. And if that's the case, because they might also be unfit because of an intellectual impairment. So we have an expert go to assess their functioning. It might be intellectual cognitive functioning. We might need a psychologist or a neuropsychologist to go and assess their intellectual functioning, or we might have a psychiatrist go and talk to them and assess whether there is a mental illness and whether that mental illness is causing an inability or an impairment in being able to understand the case against them, being unable to instruct their lawyers properly, being unable to concentrate long enough to sit through their case. And in the district court and Supreme Courts, if somebody is believed by the experts, psychiatrists for the defence and the prosecutor, if they run through a series of questions, specific questions, which is now in the legislation. The law recently changed, and the new piece of legislation has these sorts of criteria set out in the legislation. It used to be from an old case in Victoria called Presser, but essentially now that's enshrined in the legislation. And if the person cannot understand one of those criteria, then the psychiatrist or the psychologist thinks that they're unfit, then we go to court for a judge and have a fitness hearing. And then there are consequences of if a person is unfit for court and not going to become fit within 12 months, then they would, providing the prosecution is going to continue with the charges, they'll have what's called a special hearing, which is with no jury, it's a judge, and that's where the criminal charges get presented, the evidence is presented, and the judge will decide whether they have done the crime or not, and determine the length of time, if they are determined to have done it, the length of time that they may have to be detained for. There's also different verdicts of a lot of people with mental health issues. They may have a mental health impairment defence, the old not guilty on the grounds of mental illness, well, now it's a mental impairment defence. And some people with a cognitive impairment may have what's now called cognitive impairment defence, where they may not have understood what they were doing, the nature of what they were doing, or may not have understood that it was morally wrong to do it. They may have thought it was okay and it was right to do it. So again, you need expert evidence, you need expert opinion on this. This is not the lawyers trying to get somebody off or anything like that, because the consequences are really quite tough if you go down this path. It doesn't mean freedom. It can mean being under psychiatric or psychological care for very, very long time, and some people will be detained in a forensic hospital for a very long time, not free, and so the consequences of a verdict of impairment, cognitive impairment or a mental impairment, not criminally responsible due to the impairment, but the consequence is not necessarily that you're free in the community. You may be in a facility, especially for the more serious charges like murder, then it'll be a very, very long time before if at all, that the person is outside in the community. There are reviews by the Mental Health Review Tribunal, and when a person is found unfit, or when a person is found to be having an impairment defence, then they will be reviewed by the Mental Health Review Tribunal, and every 6 months they'll be reviewed to see how they're responding to medication, if they require the medication, to make sure that they are complying and taking their medication if medication is required. And the tribunal can impose conditions on people. Some people will be placed on a community treatment order, and that they may be compelled to have medication, often by injection at their doctor's surgery or by their mental health team. And in the local court, there are still the Section 32 applications, where instead of being given a criminal penalty, you are transferred down the path of getting treatment by your local area mental health team. So we have an expert report saying this is the person's conditions, this is the situation, this is what the person needs, here's the plan. They need treatment, they need these conditions put in place, and they have they have a doctor to go to, and this will be the plan if this is ordered, rather than giving them a penalty, rather than convicting them, rather than giving them a fine or jail penalty or some sort of order which doesn't focus on their treatment. Section 33 is where somebody may have to be sent from court to a psychiatric unit at hospital. For example, they might have to get urgent medical attention and then be brought back to court once discharged from hospital. So we have a lot of clients that we have to deal with this legislation. They've got criminal charges, and they're mentally ill or intellectually impaired, and we have to have these two pieces of legislation and protocols in place, trying to get them help while they're also in the criminal justice system. So the law has recently changed this year. The new law came in at the end of March. The cognitive impairment defence, in a sense, came in, as well as a change in the name for the mental health impairment, the mental illness defence. So changes are being made. We're still learning all the new terminology and the new sections of the legislation, but this is a big part of what Sarah and I do as well, big part of our job.
Okay, thank you. All right, well, I think we're just about at the end of our webinar. There's just a couple of words here, Sarah. You've been good at quoting television drama when it comes to criminal law words. Some of these words are ones we don't use in New South Wales that people might have heard.
No, so you're correct. We don't use these words. I might just go through and explain. We have sort of equivalent concepts in criminal law in New South Wales. So a misdemeanor is a less serious crime. Obviously in New South Wales, as we've explained, we divide them into summary offences and indictable offences, whereas in America they use misdemeanor and felonies. It's just a different way of distinguishing between different crimes and the level of seriousness, and therefore how we deal with them. In America, they have first, second, and I think even third degree murder. I'm not entirely sure how they divide it up, but I think it comes back to intent and the level of intent and the level of premeditation. In New South Wales, we have murder and then we have manslaughter. So that's the only distinction in terms of offences that we make. In terms of murder, the prosecution can prove the intent to murder a variety of ways. And then obviously, depending on any factual findings that would affect the seriousness of a particular case of murder, but we don't divide the offence itself into different degrees like they do in America. That kind of distinction would be done on a factual level at sentence if someone was found guilty or pleaded guilty. Early release for good behaviour. We don't have a concept of early release. As we've explained, we've got the non-parole period and then the parole period. If someone gets a non-parole period under 3 years, they're automatically released on parole once that 3 years in custody has occurred, or 3 years or less. If someone gets longer than 3 years, then it's up to the parole board to decide whether that person should be released. And the parole board would look at things, including whether that person has been of good behaviour in custody, and whether they've been, whether they have any punishments that they've received in custody. So if they've done the wrong thing in custody, or the extent to which they've rehabilitated themselves, that would get looked at in terms of deciding whether someone gets parole. But we don't have, someone can't get released from custody before their non-parole period has expired in New South Wales. One exception for that is there was emergency legislation put in place because of COVID to potentially release someone before their non-parole period had expired. That's been agitated again this week because of the COVID numbers in custody, but it's an emergency measure. It's not a usual practice. In terms of plea bargaining, we don't have the same concept of plea bargaining as they do in America. In America, from what I understand, they can essentially, the defence and the prosecution can essentially agree on the outcome. So they can say, if we plead to this, you'll only get 5 years. We have a slightly different concept of negotiation with the prosecution. We certainly do negotiate, and in fact, with serious crimes, it's part of the process and it has to occur. But in Australia, or in New South Wales, it's about negotiating what the charges are and the facts that would sit behind those charges. The prosecution is not allowed to, doesn't have a role in determining what the sentence is, and in fact can't even tell the court what they think the sentence should be in numerical terms or with any sort of level of specifics, because it's an error. So they can indicate, we think this matter deserves prison, or we don't think this matter deserves prison, but they're prevented from going beyond that.
Okay, thank you. All right, just before we get to some last questions, the slide coming up now is just to let you know that there's lots of publications on the Legal Aid New South Wales website that you can look through if you want to understand some of these criminal offences in more detail. And the email that's coming after the webinar also has links to a range of resources that you can use if you want to find the definitions of legal words used in criminal law matters. So that's just telling you about that. The next slide coming up, telling you about the next two. Well, these are the last two that we're running for the year. Legal Words for Interpreters webinars, both happening in October and in the same week. I'm not sure how we managed that, but that's what's happened. So we've got Mental Health and Housing Law Words on Tuesday, the 12th of October, and Family Law Words on Thursday, the 14th of October. And this webinar is being recorded, so you'll find this and all our other interpreter webinars up on the Legal Aid New South Wales YouTube channel. So just going to our final questions, I've got a few here that have been asked. Someone has asked, do solicitors work in the higher courts, so beyond the district court? Do you want to answer that, Helen? Yep. The answer's
we
simple.
Do. Yeah. So yes, we work in Supreme Courts. Solicitors instruct in the High Court as well. So usually barristers will always have an instructing solicitor, and the solicitor helps the barrister prepare and present the case. So yes, we do local court, district court, Supreme Court, Court of Criminal Appeal. Legal Aid has a whole indictable appeal unit of solicitors who instruct counsel in the Court of Criminal Appeal. And also they will also do High Court appeals, instruct counsel in High Court appeals.
Okay, so they've got here is, so indictable offences are prosecuted by, well, they say DPI or police, but I think they might mean
DPP.
DPP, yeah. Yes.
Yeah. So basically, police prosecute all matters that are in the local court. As Helen explained, there's different categories of indictable offences. So some indictable offences can be finalised in the local court, and there are some which have to be finalised in a higher court, be it the district court or Supreme Court. If a matter goes to the district court or Supreme Court, it has to be prosecuted by the DPP. The DPP very occasionally also prosecute matters in the local court. So, for instance, they regularly, if a child sexual assault matter is kept in the local court, the DPP will prosecute that. But on the whole, it's the police prosecutors that prosecute matters in the local court. So even if it's an indictable matter, the police will still prosecute.
Okay, thank you. And earlier on, someone asked, can someone plead guilty during a mention? Sarah.
Yes. So yes, I guess the short answer is, so with a local court matter that's going to be finalised in the local court, a plea can be entered at any time. So someone could enter a plea at a mention, and the process is a lot less formal, I guess, in a local court matter. The court wants the person to enter their plea as soon as possible. Sometimes that's done by the lawyer. The lawyer will say, I'm instructed to enter a plea of guilty or a plea of not guilty. And sometimes the person themselves will enter the plea. It just depends on the court practice. In terms of indictable offences that are going up to the district or Supreme Court, a person can't simply plea at any mention. There's a timetable that has to be followed, and generally a person wouldn't enter their plea until the final appearance in the local court before it gets committed. And at that stage, they'd either say they're pleading guilty and the matter will be committed for sentence, or they're pleading not guilty and the matter is going to be committed for trial. You then have the arraignment process, which is held in the court that will ultimately hear the trial or sentence. Again, it depends on court practice, but generally if someone is going for trial, they'll have to formally enter their plea. So the charges will be read out in court and they'll have to say to the court, not guilty. So it's a much more formal process with the more serious offences.
Okay, thank you. And someone's asked, when do you get a QC or an SC involved? Helen, do you want to answer that?
Yeah, sometimes, look, there are very good junior counsels who have been barristers for years and years and years that you don't necessarily need a QC or an SC. Some clients have that perception that they need somebody with that title, and I think it's a wrong assumption, because, as I said, there are many junior counsel, junior as in they are not senior counsel or SC or QC, who do years and years of trial work and are excellent. They just haven't bothered or not interested in going for that extra title of SC or QC. I think really the best thing to do is to select a barrister that specialises in the type of case that you have. So some people may have a background in accounting as well, or they might be very good at those sort of technical issues that you need in a fraud case that may involve a lot of details and complicated details. They might have a specific very good talent or background in that area. Other barristers might be very good at technical legal arguments, and so your case might be really technical, and you might think that person's way they think is really suited to your type of case. And other cases may not have so much legal argument, but really might need some strong cross-examination of witnesses, conflicting accounts and everything. So, and also which barrister is going to suit your client the best as well, in terms of your client's personality and the barrister's personality, because if you need your client to give evidence in court, depending on what type of case it is, if it's a sort of case where your client really needs to consider giving evidence, but your client and the barrister do not get along because there's a personality conflict, the barrister's not going to get the best out of that client in court. The client won't feel comfortable opening up to them, or, you know, they might, whatever the clash is, whatever the problem is. So you have different, I think the personality as well as the skill set are important factors when choosing a barrister.
Okay,
more
thank
so
you.
than the title, more so than the title.
So just a couple of terms, Helen. Can you explain without prejudice?
Okay, so you want to make an offer. You might want to say, look, you know, my client would be willing to plead guilty to steal from person, but I don't. I'm not locking it in. Don't this is not certain yet, but we want some other, we would like this charge withdrawn, that charge withdrawn in return for a plea of guilty to, for example, steal from person. So you're really using it in negotiations. You don't want anything that may be considered an admission of guilt in case the negotiations fail, so that the negotiations cannot be used against your client at a later time, especially if the prosecution rejects the offer. You don't want it prejudicing your client down the track later on. So it's really used when you're negotiating.
Okay, and the next one is these terms: stand the matter down, stand the matter off, stop the matter. Are they all the same terms, and what do they mean?
So they're different, but stand the matter down will be you're in court and the magistrate or the judge might want you to go and get some further information, make a phone call, go and get a document, or you might apply, look, Your Honour, may I please stand the matter in the list? Can I seek a short adjournment? Go and get the document, go and make a further phone call. And so you're coming back. The idea is it's meant to be a short time. You are coming back that day, but you need to go and do something first, or it might be stood down till 2 p.m. for judgment. You may have made some submissions already on a sentence matter, and the matter might be stood down till 2 p.m. for judgment, and the judge wants time to think about the matter and will come back into court at 2 p.m. and give you the final result, the final judgment. So yeah, stand the matter down is just a temporary adjournment.
Okay. Why do opposing counsel call each other my friend over there?
yeah, they're hardly friendly sometimes. It's tradition. It's tradition, and it can be very difficult when that person has not been very pleasant. But it's tradition, it's convention, and I think it's something that's really hard for clients to understand, because they don't want you being friendly with that person. They don't want you. Some clients are quite shocked at that tradition. It's just a tradition.
It's not that they are the best mates after
No.
court.
No.
And I'm pretty sure you covered this, Helen, but I'll just ask you to explain again the difference between larceny and stealing.
They're really the same thing. They're really theft, larceny, stealing. They're really, in effect, the same thing. It's taking of property with the intention of depriving the owner of it. They're really essentially words for the same thing. And when you look through the Crimes Act, there's larceny by a clerk, all types of different larceny, different things going back through the ages. The Crimes Act started off in 1900, and gets updated, but theft of cattle, and they're all different things, different situations, but it's really stealing. All of it: stealing, larceny, theft. They're all taking somebody's property when you do not have permission to do it, with the intention of depriving them of that property.
Great, thank you. And last question here, Sarah, what is the consequence of a no-show at your mention?
Well, that's a good question. It depends. So it's a matter for the magistrate to decide, and they'll take into account different considerations. So if your client doesn't turn up and they have a good reason for not turning up, then the court might simply adjourn the matter to a later date to give the client an opportunity to turn up. The court could also issue a warrant for that person's arrest because they've failed to show up at court. If a person was due to have a hearing or they're due to be sentenced, they may also be in the local court convicted in their absence. and then a penalty will be imposed, and it will be up to that person to then lodge an appeal against that conviction. In the district court, someone wouldn't be convicted in their absence, but the court could decide to issue a warrant for the person's arrest. But generally, if a person has a good record of attending and for whatever reason can't turn up on a particular date, the court will often give them the benefit of the doubt the first time, but obviously the more someone fails to turn up, the less understanding the court will be. And that might also be a reason why you'd stand a matter in the list to see whether you can get your client to turn up, because sometimes they've just slept in.
And if the lawyer doesn't no-show, then that's a whole different problem. But
yes,
the lawyer has forgotten to turn up to court. So sometimes you're there and the judge is saying, "Where's the legal representative?" It does happen. But they're at a different court and they're on their way. But it does happen where the judge is trying to find out who the lawyer is for the person. So.
Okay. I might just get you, Sarah, I know we haven't had that on our slides, to just explain what a warrant is.
Oh, of course. So a warrant, when it's issued by a court, is requiring that if a person is picked up by the police, that person is brought before the court to be dealt with. Generally, where this happens, as I've explained, is if someone was due to turn up for a mention or for some other procedure to take place and they don't, then the court will issue a warrant, and the warrant will lie until such time as the person is picked up. The warrant is then executed, and the warrant essentially gives the police the power to bring that person before a court. The other time it might come up is if someone was subpoenaed to give evidence and they don't turn up, and then the court may also issue a warrant for that person's arrest.
Okay, thank you. Well, I think we've come to the end of our time. Thank you very much, Sarah and Helen, once again for your amazing webinar about criminal law words, and for everyone's participation today, for your questions before the webinar and during the webinar today. Just a reminder that when we close the webinar, you'll get a survey, and we appreciate your feedback, as well as telling us what other topics you'd like us to cover through our webinars, and you'll also get an email with some links to some resources, online dictionaries that you can use if you're wanting to check the meanings of words used in the matters that you're interpreting in. And yeah, so we look forward to welcoming you all to our next Law for Community Workers webinar. I know many of you do come along to multiple webinars, which it's great to see you. And so people are saying thanks, Sarah and Helen, for your time today. So yeah, an amazing webinar with amazing lawyers. That's what they're saying.
Thank you. Thank you to everyone. And thank you also to our host, Kerry. Thank you very much.
Oh, no problem. All right, well, we'll say goodbye, and we'll see you next time. All right. Bye for now.
Bye-bye.
See you.